Gun rights are at the forefront of discussion today as the U.S. Supreme Court issues a major ruling.
All right, we've got this breaking news just coming into our newsroom right now.
The Supreme Court just came down with its biggest Second Amendment ruling in more than a decade.
Breaking news this afternoon is the Supreme Court decided to lift an injunction allowing the administration to end TPS.
A major blow to TPS recipients.
That seems like guilty until proven innocent. That's not within the lawful jurisdiction of a government.
The Supreme Court just changed everything. 6 justices against 3, and with one decisive ruling, they've redrawn the boundaries of government power in ways that will touch every American's life. This isn't about politics or picking sides. This is about the fundamental question of who watches the watchers. And today, we finally got an answer. Right now, over 600,000 Americans are waking up to a new reality. But here's what the headlines aren't telling you. This ruling reaches far beyond those directly affected. It strikes at the heart of a shadow system that's been monitoring your bank accounts, tracking your digital footprints, and operating outside the bounds of constitutional law for years. For over a decade, a silent war has been raging in America's courtrooms. Not a war between political parties, but a battle over the very architecture of government power. Federal agencies have been collecting data on millions of citizens without warrants. District judges have been wielding nationwide authority from single courtrooms, and programs designed to last months have stretched into decades through bureaucratic sleight of hand. Today's Supreme Court decision didn't just end these practices, it exposed them, and the implications are staggering. Let's start with what actually happened. The highest court in the land looked at a system where temporary had become permanent, where surveillance had become standard, and where constitutional limits had become suggestions. They said no more. But to understand why this matters to you, we need to pull back the curtain on how we got here. Back in 1990, Congress created something called temporary protected status. The idea was simple and humanitarian. When natural disasters or conflicts struck other countries, America would offer temporary shelter to those affected, 6 months, maybe 18 at most. Then people would return home when conditions improved. Fast forward to today, the average person on this temporary status has been in America for 12 years. 12 years on something with temporary in the name. But this isn't just about one program, it's about a pattern that reveals something much darker about how power operates when nobody's watching. Here's where it gets interesting. While immigration advocates were fighting to keep temporary programs permanent, something else was happening in the shadows of the financial system. The Financial Crimes Enforcement Network, buried deep within the Treasury Department, launched what they called a temporary emergency surveillance program in 2018. It was supposed to last 90 days. Just 3 months to catch some financial criminals. 6 years later, that temporary program was still running. But it wasn't just running, it had evolved into something monstrous. 30 million banking transactions every single month were being swept up into government databases, not 30 million suspicious transactions, 30 million ordinary transactions from people buying coffee, paying rent, sending birthday money to their kids. The government wasn't getting warrants for any of this. They were using something called the third-party doctrine, a legal theory that says if you share information with a bank or a tech company, you've given up your privacy rights to that information. So instead of going to a judge and proving probable cause, agencies just demanded bulk data from companies, then used algorithms to decide who looked suspicious after the fact. Among those caught in this dragnet were 600,000 small business owners. Their crime? Making frequent deposits, transferring money between accounts, running businesses in ways that looked unusual to a computer program, but were completely legal to anyone who understood how small businesses actually work. These weren't drug dealers or terrorists. They were entrepreneurs who found themselves under federal investigation because an algorithm didn't like their banking patterns. The average cost to these business owners, $47,000 each in legal fees and lost business, nearly $30 billion in economic damage to innocent Americans. But the surveillance state and the immigration system were using the same playbook. Create something temporary, extend it indefinitely, then argue it's been in place so long that ending it would cause chaos. It's brilliant in its simplicity and terrifying in its implications. The masterminds behind keeping these systems in place weren't elected officials. They were federal judges and agency bureaucrats who had discovered they could reshape American law from their offices and courtrooms. Take Judge Edward Chen in San Francisco. Before becoming a federal judge, he spent years as an attorney and board member for the ACLU. Once on the bench, he turned his courtroom into a one-stop shop for anyone wanting to block government enforcement. Over 40 times, Judge Chen ruled against executive enforcement actions. He pioneered something legal scholars call injunction creep, extending deadlines month after month, year after year, until temporary became permanent through judicial decree. A single judge in California was effectively dictating national policy for all 50 states. The Ninth Circuit Court of Appeals, already the most overturned court in the country, backed him up every time. Together, they created a shadow legal system where geographic forum shopping could override constitutional authority. If you didn't like a law, you just had to find the right judge in the right district and you could block it nationwide. Meanwhile, federal agencies were playing their own games. When privacy advocates challenged bulk surveillance, agencies hid behind that third-party doctrine. They argued that modern technology had made the Fourth Amendment obsolete. Why get a warrant to search one person when you could vacuum up everyone's data and sort through it later? The Drug Enforcement Administration was collecting bulk telephone records. The National Security Agency was gathering internet metadata. Customs and Border Protection was searching electronic devices at borders without any suspicion of wrongdoing. When you added it all up, virtually every American was being monitored in some way. The numbers are staggering.
This is something that actually comes from common law England. The king is sovereign, and the government has to waive that sovereign immunity.
Open carry has historically been regulated. The U.S. Supreme Court has said those types of regulations would be improper.
It's not the gun owner, it's not the pistol permit holders, it's the criminals that are causing the violence and the gun problem.
It is unconstitutional to restrict someone's rights based on the size of the place that they live, the city or county that they live in.
Financial surveillance databases contained records on over 150 million American adults. That's not a list of suspects. That's basically everyone who uses a bank. The government had created a system where being a normal person doing normal things could trigger an investigation. This is where the Supreme Court stepped in. The 6-justice majority didn't just rule on the specific cases before them. They dismantled the entire framework that allowed these abuses to flourish. They looked at the word temporary and said it means what it says. They looked at the Fourth Amendment and said it still requires warrants, even in the digital age. The 3 dissenting justices took a different approach. They focused on humanitarian concerns and practical enforcement challenges. Justice Jackson wrote about the harsh conditions people would face if forced to return to their home countries. Justice Sotomayor warned about sophisticated criminal networks that could exploit privacy protections. Their argument essentially boiled down to this: modern problems are too complex for 18th century constitutional principles, but the majority saw through this logic. If the standard for government action is simply that officials can articulate a compelling reason, then constitutional limits mean nothing. There will always be a crisis. There will always be bad guys to catch. There will always be a humanitarian concern. If we abandon constitutional principles every time things get complicated, we don't have a constitution at all. The majority opinion was blunt. Temporary means temporary. The Fourth Amendment doesn't have a technology exception. Constitutional protections apply with even greater force in the digital age, not less. By allowing judges to impose their policy preferences and agencies to exploit technological capabilities, we had created unlimited government power through bureaucratic and judicial decree. This ruling changes everything. For the 600,000 people on temporary protected status from countries like Venezuela and Haiti, it means facing choices they thought they'd never have to make. But when you include every country that received temporary designation over the last 15 years, we're potentially looking at 1.2 million people living in a legal fiction that's finally being exposed. For the millions of Americans whose financial data was being collected without warrants, it means the restoration of privacy rights that had been slowly eroded through technological exploitation. Federal agencies now have 90 days to completely restructure their surveillance operations to comply with warrant requirements. The ripple effects are already beginning. Homeland Security Secretary Kristi Noem has signaled that enforcement actions will ramp up through specific target dates in April. Agencies that relied on bulk data collection are scrambling to develop new procedures. The parallel systems that operated outside constitutional constraints for years are being dismantled, but this is bigger than any single program or agency. This ruling establishes precedents that will reshape how the federal government operates. The reasoning that ended these temporary status extensions could be applied to challenge DACA. The logic that closed surveillance loopholes applies to every program that collects bulk data without individualized warrants. We're witnessing a fundamental restoration of constitutional government. Power is flowing back from unelected judges and faceless bureaucrats to elected officials operating within constitutional limits. The Supreme Court has made every future election a referendum on how that power will be used. Immigration advocates warn of chaos and disruption. Privacy advocates who support surveillance reform worry that agencies will find new workarounds. They're right that change is coming fast. But the majority opinion addressed this directly. The real chaos was caused by courts and agencies that refused to follow constitutional limits for years. By allowing temporary to become permanent and surveillance to operate without warrants, the system created false expectations. This ruling sends a clear message. America is no longer a country where you can bypass the system and expect judges or bureaucrats to protect you indefinitely. Federal agencies cannot use technology as an excuse to ignore the Fourth Amendment. The law means what it says, and temporary actually means temporary. The 2026 midterm elections just became far more consequential. With power restored to its proper constitutional channels, voters now know that their choices actually matter. Whoever controls the executive branch has real authority to enforce immigration law. Congress must either properly authorize surveillance programs or shut them down. There's no more hiding behind activist judges or bureaucratic complexity. What we're seeing is the dismantling of a shadow system that operated for years outside constitutional bounds. 600,000 people are facing immediate consequences. Millions more are regaining privacy protections they didn't even know they'd lost. This isn't just a legal victory for one side or another, it's a restoration of the basic principle that in America, the Constitution isn't optional. The changes are coming fast, and the legal landscape shifts daily. This 6-3 decision represents more than a single ruling. It's a fundamental reset of how American government operates. The rules actually mean what they say again. Constitutional protections aren't obsolete just because technology has advanced, and the days of permanent temporary programs are finally over. That's it for today, folks. See you in the next video.